Welcome to Do It for the Case Law for Monday, August 3rd, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today we are covering 58 federal appellate decisions across 5 reporter beats. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Turning to criminal justice, James has the latest from the federal circuits.
Thanks, David. 21 criminal justice cases today. The dispositions break down as 19 affirmances, 1 dismissal, and 1 vacatur and remand. Leading with the movement in the Fourth Circuit, the court vacated and remanded United States v. Bielhars. The district court had partially granted a motion for reconsideration regarding a garnishment order, but the appellate court held it lacked jurisdiction because a notice of appeal was already pending. Under Federal Rule of Criminal Procedure 37, a district court cannot alter the status of a case while an appeal is active. The modification was deemed a nullity, and the case returns to the district court for further proceedings consistent with this ruling. Moving to the 10th Circuit, 2 affirmances came down on Fourth Amendment and evidentiary grounds. In United States v. Beard, the court affirmed a life plus 10-year sentence for first-degree murder in Indian country and a firearm use conviction. The court found sufficient evidence of premeditation, noting Beard trapped his victim and video footage showing the victim with hands up was shot at point-blank range while motionless, defeating self-defense claims. Any error in admitting hearsay regarding tribal status was harmless given other admissible evidence. In United States v. Underwood, the court affirmed a drug conviction by rejecting a suppression motion. The traffic stop was constitutional because the officer had reasonable suspicion that the driver violated Oklahoma law prohibiting stopping on the roadway when it is practicable to pull over. P.S. The area was unimproved land, not a residence district exempt from the statute, and the officer provided specific facts supporting the impracticability of moving the vehicle. In the 11th Circuit, the court affirmed 2 convictions and dismissed 1 appeal. In United States v. Bostic, the court affirmed wire fraud and money laundering convictions despite plain error in admitting an FBI agent's opinion testimony on the defendant's knowledge. The error was harmless because other overwhelming evidence established guilt. In United States v. Pineda-Torres, the court affirmed a Maritime Drug Law Enforcement Act conviction, holding that Congress has constitutional authority to punish drug conspiracies on the high seas under the Necessary and Proper Clause, rejecting a nexus argument based on conduct in Colombia and international waters. Finally, the appeal in United States v. Hickman was dismissed pursuant to a valid plea agreement waiver. The 6th Circuit issued 3 affirmances involving firearms and sentencing enhancements. In Starling, the court affirmed a felon in possession conviction and Armed Career Criminal Act enhancement, holding that prior Tennessee drug convictions qualified as serious drug offenses under the modified categorical approach. The defendant also forfeited his constructive amendment claim by failing to raise it timely. In Gardner, the court affirmed a similar ACCA enhanced sentence, rejecting a due process claim over lost dashcam footage. Under Arizona v. Youngblood, negligence or even gross negligence does not satisfy the bad faith requirement for suppressed evidence. Gardner showed no official animus. The district court had already sanctioned the loss with an adverse inference instruction. In Battle, the court affirmed a methamphetamine sentence, holding that a prior marijuana possession conviction properly counted toward criminal history under the sentencing guidelines and denying a mitigating role adjustment based on his significant participation in the offense. The 8th Circuit affirmed 3 judgments involving competency and supervised release revocations. In Chrisley-Peterson, the court affirmed a competency finding and granted counsel's Anders motion to dismiss substantive reasonableness challenges barred by an appeal waiver. In Higgerson and Davidson, the courts affirmed supervised release revocations and sentences above advisory guidelines, applying abuse of discretion review and granting counsel motions to withdraw after finding no non-frivolous issues. Wrapping up in the 9th Circuit, we see 19 cases. The most significant is United States v. Ridley Thomas, where the court affirmed convictions for bribery and honest services fraud. The court held that funneling $100,000 from campaign funds through a university to charities for the benefit of his son constituted a thing of value under Section 1346 and Section 666, rejecting the argument that personal enrichment or tangible benefits are required. Also notable is Hall v. City and County of Honolulu. The court affirmed summary judgment in a Section 1983 civil rights suit holding that an officer's characterization of a plaintiff retaining a former employer's phone as borderline extortion was not motivated by retaliation for filing a criminal complaint under Nieves v. Bartlett, and equal protection claims failed due to rational differences in investigative posture. The remaining 9th Circuit cases were routine affirmances or dismissals based on valid appeal waivers. In Ramirez, Flores, Reyes-Hernandez, Espinoza-Romero, and Hull, the courts affirmed convictions and sentences for coercion, enticement, illegal images, deportation offenses, and drug distribution. In Flores, the court also dismissed the appeal regarding waiver enforceability after counsel filed an Anders brief and the defendant did not file a supplemental brief. In Reyes-Hernandez, the court affirmed a 37-month sentence, noting that referencing dismissed sexual assault charges did not violate due process, as the sentence relied on immigration history and criminal record. Back to you, David.
Thanks, James. Let's turn to Aisha for civil rights and employment coverage.
Thanks, David. 10 cases today across 4 circuits. The mix includes 2 reversals and remands and 8 affirmances or dismissals. In the Eighth Circuit, a split outcome in Zachary Hamby's religious accommodation suit against Iowa prison officials stands out. The Eighth Circuit reversed summary judgment on his Religious Land Use and Institutionalized Persons Act claims regarding administrative exhaustion, holding that he created a genuine issue of material fact about whether staff allegedly ignored his grievances. However, sovereign immunity barred his Section 1983 claims against state actors in their official capacities. Also in the Eighth Circuit, Dan Larry Pennington won a reversal on statutory royalties from oil and gas operators. The court held that Arkansas law does not allow lessees to deduct post-production costs from gross proceeds under private leases requiring payment based on those proceeds, resolving an ambiguity in the state statute against the operators. In the Tenth Circuit, the court affirmed the denial of a motion to dismiss in United States v. Doe. The court upheld the constitutionality of the federal juvenile handgun possession ban under the Commerce Clause, finding Congress had a rational basis for regulating juveniles out of handgun markets as part of a comprehensive regulatory scheme. Moving to the 11th Circuit, 2 employment and civil rights suits were affirmed. In Haley Cole v. Accenture and its executives, the court upheld dismissal of her Title VII claims as time-barred and rejected personal jurisdiction over individual defendants in Georgia. In Roger Lee Mathis v. South Fulton Police Department officers, the court affirmed qualified immunity for police who arrested him based on arguable probable cause despite his self-defense claim. In the Sixth Circuit, Dawn Wortham's employment discrimination and retaliation claims against the city of Detroit were affirmed. The court held the city had a legitimate non-discriminatory reason for firing her due to absenteeism and failure to provide medical documentation, and she could not prove pretext. The Ninth Circuit handled 4 cases, all affirmances or dismissals. In Griepsma v. Anderson, the court affirmed summary judgment for defendants in a prisoner civil rights action, holding Griepsma forfeited review of his excessive force claims by failing to move for judgment notwithstanding the verdict. In James v. the State of California, summary judgment was affirmed regarding conditions of confinement and false arrest during extradition. In Saleko v. Franklin, the court affirmed dismissal based on tribal sovereign immunity. Finally, in Marceau v. the County of Maricopa, a pro se Section 1983 action regarding real property was dismissed for failing to state a plausible claim. Back to you, David.
Thanks, Aisha. Michael, let's hear from you on the constitutional law docket.
Thanks, David. 4 cases on the constitutional law docket today, and here is the breakdown. 1 dismissal, 2 affirmances, and 1 split outcome where the court affirmed in part and reversed in part. Let's start with the 11th Circuit, which dismissed an appeal by Justin Michael Rossi against the Florida Department of Children and Families. The court found it lacked jurisdiction because the underlying orders denying a motion for appointment of counsel and a hearing were not final or immediately appealable under the collateral order doctrine. Since any error could be reviewed upon final judgment, this premature appeal was dismissed, and all pending motions were denied as moot. Moving to the 9th Circuit, we have a split outcome in Przopke versus the United States Department of Agriculture. The court reversed the district court's dismissal of First Amendment challenges regarding federal food labeling regulations that prohibited FODMAP information on product labels. For one plaintiff, the court applied listener standing, finding she had a concrete connection to speakers who were deterred from including that speech by the regulations. For other plaintiffs, the court found a credible threat of prosecution under pre-enforcement challenge standards. This reversal means the First Amendment claims can proceed. Also in the 9th Circuit, 2 routine affirmances in prisoner litigation. In Bailey v. Mejia, the court affirmed the district court's post-judgment order because Bailey failed to file a timely notice of appeal from the underlying dismissal and abandoned his motion for reconsideration by not addressing it in his opening brief. In Dunlap v. Thomas, the 9th Circuit affirmed summary judgment for defendants in an Eighth Amendment inadequate medical care claim. The court held that Dunlap's disagreement with his medical plan did not demonstrate deliberate indifference or show that the treatment was medically unacceptable. Back to you, David.
Thanks, Michael. Maria has the business and civil updates.
Thanks, David. Maria Santos with Business and Civil Law. 13 cases in this block, 12 were substantive rulings, and 1 was a grouped lower priority matter. The disposition mix includes 1 reversal and remand, 1 vacatur and remand, 1 certification to state court, 1 grant of review and remand for further proceedings, and 8 affirmances or other administrative corrections. Starting in the First Circuit, 4 errata sheets were issued. The court corrected a clerical error in Muchiri against Blanche by replacing a pronoun with immigration judge on page 6. Another erratum in the same case fixed a grammatical reference on the same page. A third correction in United States against Eric Robert Johnson replaced investigations with investigation and struck extraneous text on page 9 to clarify how Freenet performs its functions. The fourth corrected a typo in United States against Ray David Fulcar, replacing perpetuated with perpetrated on page 19. Moving to the Seventh Circuit, one substantive case stands out. In Gomez against Kohl's Corporation, the court certified a question of Wisconsin state law to the Wisconsin Supreme Court. The issue is whether a plaintiff suffers pecuniary loss under the Wisconsin Unfair Trade Practices Act when buying a product falsely advertised as on sale, where the product itself is worth the purchase price. Because no Wisconsin decision squarely addresses this and persuasive authority is split, the Seventh Circuit could not decide if the class action fair CA amount in controversy threshold of $5 million was met. The case was remanded so the state court can answer the question. In the Eighth Circuit, one mixed outcome. Northland Management against the City of Parkville saw the court affirm inverse condemnation in Class of 1 equal protection claims but reverse and remand for recalculation of damages. The court held that denying a final certificate of occupancy constituted unreasonable enforcement of land use regulations causing a nuisance under Missouri law, satisfying inverse condemnation because Northland's grading complied with the city-approved plat. For equal protection, the city intentionally treated Northland differently from similarly situated owners without a rational basis. However, the damages award was reversed because the district court based losses on diminished value rather than actual harm. Finally, in the Ninth Circuit, 8 cases. 2 were vacated or remanded for procedural reasons. In Dardison against Connor, the court vacated dismissal with prejudice of Lanham Act and state law claims. Applying abuse of discretion, the panel noted the plaintiff is an incarcerated prisoner who did not receive electronic service and lacked notice of the amendment order, warranting another chance to comply rather than harsh dismissal. In Singh against Blanche, the court granted review and remanded for further proceedings on asylum and withholding of removal. The BIA committed reversible error by failing to conduct a reasoned analysis of whether Singh could safely relocate within India, ignoring his specific persecutors and intent to proselytize, instead relying on impermissible speculation about persecution of Sikhs generally. One case was affirmed on state law limitations grounds. In Hopkins against Callahan, the court upheld summary judgment because all claims were time-barred. Breach of fiduciary duty claims failed under California Probate Code Section 1646A because Hopkins knew or should have discovered the facts more than 3 years prior. Intentional infliction of emotional distress was untimely under Civil Procedure Code Section 335(1). One affirmed dismissal for failure to amend. In Roberts against Studio 15, the court upheld dismissal under Federal Rule of Civil Procedure 41B for failing to prosecute or comply with a court order to amend the complaint. One affirmed summary judgment in a tort action. In Grenier against USA, the Ninth Circuit affirmed judgment for the United States in a Federal Tort Claims Act case alleging medical malpractice at Tripler Army Medical Center. The district court did not abuse discretion in excluding the plaintiff's rebuttal expert because his testimony was duplicative and should have been disclosed initially. Although the district court erred by admitting undisclosed expert testimony from providers, this error was harmless. One affirmed confirmation of a foreign arbitral award. In Shenzhen's Zhejiang Investment Center against Yinghui, the panel held that general personal jurisdiction existed because Yinghui was physically present in California. The Due Process Clause does not require direct service on the person. Jurisdiction is satisfied if a voluntarily present defendant receives notice through alternative means reasonably calculated to provide actual notice. Yinghui waived his challenge to service sufficiency by failing to raise it properly. Back to you, David.
Thanks, Maria. Raj has the immigration and government docket.
Thanks, David. I have 10 cases from across the country, 10 total cases today, 1 reversal and remand, 1 dismissal of appeal, 2 reversals, and 6 denials of petitions for review or motions. Let's start in the First Circuit. African Communities Together versus Markwayne Mullen is a significant development regarding temporary protected status. The government appealed a district court order continuing an administrative stay of TPS termination for Somalia nationals. The First Circuit dismissed the government's appeal and remanded the case for further proceedings. The court treated the district court's July 31st order as an indicative ruling under Federal Rule of Civil Procedure 62.1 that the district court would dissolve the existing administrative stay if jurisdiction were returned to it. Consequently, the First Circuit declined to retain jurisdiction and ordered the mandate to enter forthwith. Judge Dunlap dissented, arguing the open-ended administrative stay should have been vacated because it effectively granted injunctive relief without the movement meeting the burden of demonstrating likelihood of success on the merits. Moving to the 10th Circuit, Green Latinos versus Suncor Energy is reversed and remanded. The 10th Circuit held that the district court incorrectly applied the Clean Air Act's diligent prosecution bar. The court determined this bar is a non-jurisdictional affirmative defense rather than a limit on subject matter jurisdiction. It established that the bar precludes a citizen suit only if there is a present civil action in judicial court with identical standards being enforced, excluding claims based on substantially similar but distinct regulatory requirements. In the 11th Circuit, we have 2 reversals. First, Smith versus City of Johns Creek was dismissed by the 11th Circuit for lack of jurisdiction. The court held that the district court's order dismissing claims against one defendant was not a final judgment because other claims remained pending, and it was not immediately appealable under the collateral order doctrine. Appellants must await a final judgment disposing of all remaining claims before appealing. Second, City of Brunswick versus Honeywell International is reversed. The 11th Circuit held that federal officer removal under Section 114 was proper. the defendants were acting under the Environmental Protection Agency because they performed a governmental task remediating hazardous waste at a Superfund site that the EPA would otherwise have had to perform itself under CERCLA. The court also applied the Griggs principle clarified in Coinbase versus Bielski, concluding that the notice of appeal automatically stayed the district court's remand order, rendering subsequent state court proceedings void. Finally, the Ninth Circuit issued 6 denials. Aragon Martinez versus Blanche was denied for Mexican nationals seeking asylum and Convention Against Torture relief. The court found substantial evidence supported the agency's conclusion that internal relocation to Guadalajara was reasonable, noting the child would retain access to services, and the petitioner's fear was not well-founded given safe relocation of similarly situated relatives. Cortez Vicente versus Blanche was denied for Guatemalan nationals. Substantial evidence supported the determination that petitioners failed to establish past persecution, precluding a presumption of future persecution, and they did not meet their burden under the Convention Against Torture. Hernandez Godinez versus Blanche was denied. Substantial evidence supported the agency's determination that he failed to demonstrate exceptional and extremely unusual hardship to qualifying relatives for cancellation of removal. Montoya Parada versus Blanche was denied because the petitioner failed to establish prima facie eligibility for relief, so the Board of Immigration Appeals did not abuse its discretion in denying the untimely motion to reopen. Orozco Aguilar versus Blanche was denied for a Guatemalan national. Credible death threats alone did not constitute past persecution as they were not acted upon and caused no significant actual suffering, and there was no objectively reasonable fear of future persecution. Lastly, Northam versus Bisignano is an affirmance upholding the denial of Social Security disability benefits. The court found substantial evidence supported the administrative law judge's discounting of a counseling therapist opinion due to inconsistencies with treatment notes and provided specific, clear, and convincing reasons for rejecting the claimant's subjective testimony regarding his use of a cane and attention span. Back to you, David.
Okay, that is the Daily Rundown for Monday, August 3rd, 2026. Subscribe or follow for the next update. Visit doitfortheCaseLaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction.